Namaste, I am Shivraj. We are MBA final year students and we are presenting an educational video on the topic capacity to contract under the Indian Contract Act 1872. To conclude, capacity to contract is a fundamental requirement of a valid contract under the Indian Contract Act. Thank you. In business, contracts form the backbone of the all commercials relationship, whether it's employment, finance, sales or partnership. Contracts gives the rights and obligations. However, not every agreement becomes a contract. The most essential legal requirement is capacity to contract. Capacity to contract refers to the legal ability of a person who enters into a binding and enforceable agreement. It means that the person must be capable of understanding the terms and contracts and the legal consequences arising from it. For MBA students and future managers, this concept is extremely important because managerial roles often involves negotiating, approving or signing contracts of the organization. The law restricts certain persons from contracting to prevent expiration, exploitation and unfair dealings. If a party lacks capacity to contract, becomes void or unenforceable. Even if the business interest is genuine, thus capacity to contract ensures fairness, legal certainty and ability of business transactions.
Namaste, I am Vaishnavi. This topic explains who is eligibly legal to enter into valid and enforceable contracts. The legal provision governing capacity to contract is laid down in section 11 of the Indian Contract Act 1872. According to this section, a person is competent to contract in three conditions are satisfied. First, a person must have attained the age of majority. Second, the person must be sound mind. Third, the person must not be disqualified by law from entering into contracts. If any of these conditions is not fulfilled, the person is considered legally incompetent and the agreement becomes void and unavoidable. So the objectives of section 11 is to ensure that contracts of section 11 is free consent, understanding and legal capacity. This provision protects vulnerable individuals, strengthens the reliability of commercial transactions. Now let us understand these conditions in detail, starting with minors. It ensures that only legally capable persons enter into binding agreements and protects vulnerable individuals.
Namaste everyone, I am Abhi N R. Now let's see what minor as a party to contract under a capacity to contract. A minor is a person who has not completed 18 years of age. Under Indian Contract Act 1872, only a person who is a major of sound mind and not disqualified by law can enter into a valid contract. Since a minor is considered legally immature, the law does not give them the capacity to contract. Any agreement made with a minor is void ab initio, which means it is invalid from the very beginning. Such an agreement has no legal effect and cannot be enforced by either party. This rule was clearly established in famous case of Mohari Bibi versus Dharmodas Ghosh in 1903, where the court held that a contract with a minor is always void. The main reason for this rules is protection. Minors may not fully understand the legal and financial consequences of the contract. They can easily be misled or exploited. To prevent this, the law protects minors by refusing to enforcing their agreements. A minor is not a personally liable for any contract. If if a minor falsely claimed to be an adult, the contract remains void. The principle of estoppel does not apply to minors. For example, if a minor borrow money from the lender by misrepresenting their age, the lender cannot legally cover the money from the minor. However, there is one important explanation. If a minor receives a necessaries such as food, clothing and education of medical treatment, the suppliers cannot recover the cash from the minor's priority. Not from the minor personally. This ensures that a minor can't still access essential service for their well-being. In conclusion, a minor has no capacity to contract under Indian law. Any agreement with a minor is void from the beginning. The law states that the safety and welfare of minors over business interest and ensures that they are protected from unfair and contractual obligations. Thank you.
Namaste everyone, I am Umesh. In this video, I will explain the legal rules governing contractual capacity, especially the concept of soundness of mind under contract law. According to contract law, a person must be on sound mind to enter into a valid contract. A person is considered of sound mind if at the time of making the contract or she can understand the agreement and from the rational judgment about its consequences. On the other hand, a person of unsound mind is someone who cannot understand the contract of judge its expected. This including people suffering from mental illness or those who are intoxicated due to alcohol or drugs at their time of entering into a contract. Unsoundness of mind can be permanent or temporary. For example, a person who normally mentally sound but it is temporarily intoxicated cannot enter into a valid contract during the time. However, once the person resigns soundness of mind, they can legally enter into a contract. Any agreement made during a period of unsoundness of mind is considered void because it lack of free and information content. Conclusion: the purpose of the legal rules is to protect individuals and ensure that contracts are made fairly, knowingly and voluntarily. The soundness of mind is an essential condition for a valid contract. Thank you.
Namaste, I am Vibhuti Sharma. In addition to minors and persons of unsound mind, certain persons are disqualified by law from entering into contracts. Persons disqualified by law. In addition to minors and persons of unsound mind, certain persons are disqualified by law from entering into contracts. This includes alien enemies, insolvents, convicts and companies acting beyond their legal authority. Such disqualifications are imposed to protect public interest and ensure lawful conduct. In business activities. For example, an insolvent person may have restrictions on entering into financial contracts. Any agreement made by a legally disqualified person is either void or unenforceable. These rules help maintain legal order and trust in commercial transactions. Now, in conclusion, the restrictions and exceptions strike a balance between protection of individuals and business interests.
Namaste, I am Vandhan BN. I also cover about why there is a legal disqualification and what are the exemptions. Therefore, the only persons who are major of sound and not disqualified by the law are competent in the contract, where they making the capacity to contract the foundation of the enforceable agreements. Thank you. Now let's understand why the persons get disqualified by the law and what are the important exceptions in the law of contract. Even if a person is a major and of sound mind, the law may still restrict them from entering into contracts where such persons include as alien enemies, insolvents, convicts, and even companies acts beyond their legal authority. For example, an insolvent person cannot freely enter into a financial agreement or a contract where the company cannot make agreement or contract beyond the purpose given in its memorandum. However, there is a certain exceptions, especially in case of the minors, where the contracts are made for the benefits of the minor in such as education, clothing, food, and even medical needs that are considered valid. A minor can also be beneficiary of a contract where, like receiving gift and insurance benefits from their parents or from the company. And these rules and exceptions help to maintain a balance between protecting the individuals and even allowing necessary business transaction in between them.